Esther, assist me with warm water. What did we look at last?
Okay, you had said that for my class, there are some theories that we had not covered with us, so we are to look at them, starting
So
from
we
natural
cleared with
law.
the theory.
Sorry?
Did we clear with the theories and now we are going to contract?
No. The first four laws we are here to cover: natural law, Marxist theory,
Oh,
and the
yeah.
real positivism.
Oh, you are supposed to remind me, yeah? Thank
Yes.
you. Okay. Thank you. Now, we are going to cover those ones with you. At least we covered the ones at the tail end with the other class. So let's cover that particular one with you. Okay. So your class, we didn't cover positive, realist, Marxist, and Kelsen, Sindio?
And natural law.
And natural law. So Caesar's class, 31st of January, 2024. Theories. In the next class with you, we must start contracts. Sawa. Okay. Did we cover historical and sociological?
Yes, sociological.
Okay. Sawa. Legal realism?
No.
Okay. Okay. So, like I had indicated in the course of the last class, the most important thing when looking at theory is understanding the proponents, meaning the people who understanding the concept. What is the theory about? Okay. Secondly, we need to understand. Are you able to hear me well?
Yes.
Okay. Don't worry. We'll transition to PowerPoint once my gadget powers up. In the interim, you can start as with this other gadget. You can continue. Okay. Now, I told you that for you to be able to understand the nature of law, you must understand the various theories that explain the nature of law. For you to understand the nature of law, you must understand the various theories that explain the nature of law. The question then is, what are these theories? And why are they so important? What are these theories? And why are they so important? And we agreed that these theories are imperative theory, Kelsen's pure theory of law, sociological, historical, legal realism, and natural law school of thinking. We said that they are very important and key in helping us understand the nature of law and eventually helping us to appreciate what the law is in relation to our discourse. Okay. So what is imperative theory of law? And who are the proponents? And why is it important? And why must we look at it? Okay. What is imperative theory of law? Who are the proponents? Why is it important? And why must we look at it? The imperative theory of law was put forth by somebody called Austin. Okay? Imperative theory of law was put forth by somebody called Austin. And according to Austin, law is the command of the sovereign backed by sanction. According to Austin, law is the command of the sovereign that is backed by sanction. So what Austin is saying is that unless you have the sovereign, you cannot have law. Okay? And that the sovereign is the superior that indeed formulate laws, rules, and regulation. And nothing can be done and nothing takes place without the laws, rules, and regulations that are put forward by the sovereign. And if you fail to follow these laws, rules, and regulations that the sovereign stipulates, then you'll be punished. Sanction will follow. Okay? So, if sanction is supposed to follow, then what becomes of the reasoning of a person? What becomes of the general arguments of human beings? They are saying that in this law, there is no room for reasoning. There is no room for arguments. You are not given any room for that. Okay? What you are told is that you are supposed to adhere. Okay? You are supposed to follow the laws, rules, and regulations. If you don't follow these laws, rules, and regulations, then you're punished. You are not supposed to question. You are not supposed to go before any forum and say that, you know, the sovereign made mistake. No, the sovereign is above the law. That is what they're saying. That's why it's imperative. It is also called the Austinian school of thinking or the positive school of law. Okay. And this Austinian school of thinking or positive school of law is so key to the understanding of jurisprudence. So what are the features of this theory? One, command. Command means that these are laws, rules, and regulations that govern an environment, pronouncements of the sovereign. Second feature is the sovereign. There must be a political sovereign. And this person, if you compare it to the Kenyan legal system, it could be the presidency, that is the president, his deputy, and the cabinet, or it could be the judiciary or the legislature. Okay, they are the ones who pronounce laws. They are the ones who are tasked with the process of lawmaking. Then the next feature, the final feature is sanction. Sanction is the punishment. The punishment that one suffers when one fails to follow these laws, rules, and regulation. So that at the end of the day, you are not supposed to, once the sovereign says something, you're supposed to follow. If you fail to follow, some ill will befall you. And this ill is what he calls sanction. So at the end of the day, these are the three features of the imperative theory of law. And if you compare it to your law for engineers, how is it relevant? How is this theory relevant to your law for engineers? Okay? Caesar will tell us that, you know, us as engineers, you know, in our discourse, we are supposed to only look at the principles and the rules that are governing our practice. But what we are telling you is that law, ignorance of the law, is no defense to a civil engineer. And once you are an inventor, you have your own invention, you are an innovator, you are an employer or an employee, you are supposed to follow laws, rules, and obligation without questioning. Laws, rules, and obligations without questioning. Meaning, what we are saying is that the way Austin is saying that laws are commands put forth by the sovereign is the same way. You were born, you were admitted into engineering. In fact, you completed your Form 4 and you got a placement to engineering. You have no right to question or to say that, you know what, I'll not study for 5 years. That is the law, and you have to follow it. Either you follow it, you do all these units, then you pass, or you fail to follow it, you don't do these units, then you don't graduate. So these are commands of the sovereign. And the sanction here is failure to graduate or failure to be passed by Senate for purposes of graduating. So that is a sanction. And you can't go before Senate and challenge and say that, you know what, Senate said that or passed that, we are supposed to go through that curriculum, but I looked at some of those units, they are too easy. I don't even need to look at them for that long period of time. Therefore, I need to graduate. No. You are supposed to follow to the latter and adhere to the rules and regulations of not only your training, but also of practice. Once you're done, the engineer's board is supposed to verify that indeed you followed the rules, laws, and regulations, and you are within the timelines, and therefore you are entitled to do what? To graduate. So at the end of the day, this theory, the imperative theory of law, is quite relevant to engineers because of the stint of training. That is one. Second, the governing principles of engineering, they are static. The way the training was done last year, okay, your training, it has not changed much, okay? There are still those commands that are followed, and what changes is the market forces, okay? Is the market forces. So at the end of the day, you have to ask yourself, are those laws, rules, and regulations relevant? If they are not relevant, under the Kenyan system, you can challenge. How? By going to court. How? By presenting a bill in parliament. But your challenging, as it were, cannot just come out of your failure to follow. You can't just say that, you know what, I'll not follow, therefore that is a challenge. No, nobody will know what you're doing and nobody cares. All they want to do is to know that you have finished your training, you have adhered to the procedures and processes, and you're following what is being said. Okay, so that is one, imperative theory. So what are the weaknesses of this theory? What are the weaknesses of this theory? One of the weaknesses of this theory is the sanction bit. Okay? If you look at our Kenyan legal system, if you look at our Kenyan legal system, it's clear that the laws, rules, and regulations must be, okay, must be followed to the letter, okay? And further, the laws, rules, and regulations, though followed to the letter, are first promulgated. They are published for the public to know. Yet here, it is not clear how the public will get to know, okay? It is not clear how the public will get to know, okay? Secondly, it is not clear how to deal with the unjust laws. Third, there is no room for questioning the rules and regulations that have been laid down by the political sovereign, okay? There's no room for questioning. Yet, a human being must be given an opportunity to interrogate that which is presented before them and to get to know what they need to do. Human beings have a tendency of doing what? Of challenging that which is presented before them. So if you say that a human being should not challenge, all they should do is do what? Follow what you're saying, then it means that whatever you're saying is unjust, or they are unjust laws, rules, and regulations. Okay. And then finally, this theory is not applicable to international law. Okay. What do I mean by this? The international law provides for rules and regulations among civilized independent nations. Among civilized independent nations. But if you say that there is one political sovereign who cannot be questioned, who makes laws, rules, and regulations to govern a particular people, then it essentially means that you are not taking into consideration the fact that every nation is a sovereign state. Every nation is a sovereign state, and they cannot have somebody, one person, sit on them to decide on all the laws, rules, and regulation. Okay, so we've looked at the imperative theory of law, also called Augustinian theory, or positive law, or positive school of thinking. And we've looked at the features and the relevance of this theory to you, a discourse as an engineer, as a civil engineer. We've also looked at the weaknesses of this theory. And from there, you'll see that certain definitions of law have been propounded, and that this is essentially relevant to you as an engineer. Are there any questions that far? Swali? From class? So that is imperative theory of law. Okay? Then, of course, criticisms, I've told you about criticisms, which are weaknesses of that theory. Then we'll go to the next theory and see whether it's relevant to you or not. But even before we go to that next theory, this theory, though it has been criticized widely, okay, it also has some relevance. How so? Because this is one of those theories that tries to explain, it comes up with a certain superior who is in charge of things, okay? And this superior, who is called the sovereign, essentially acts as a guide, okay, on how people are supposed to behave. And you'd appreciate this when you look at the fact that human beings, if left to their devices, can be quite destructive, you know? And because of this distraction, okay, because of this way of doing things, there's a need to always control the human nature. And that's the reason why this law is very important. This theory points to the fact that the laws, rules, and regulations are in play to control our appetites. So if a human being is left to their devices, their appetites indeed can do what? Can ruin a society as a whole. So at times you can see that the executive, the legislature, or the judiciary has dictatorial tendencies. But this is supposed to assist, or this is supposed to help in the realization of the rights of other people. You are supposed to respect the rights of other people even as you're enjoying your rights. Okay, so those are the various laws, rules, and regulation. Okay, so the second theory, is Carlson's is the legal realist theory. Legal realist theory. And legal realists believe that laws, rules, and regulations are made by judges in the course of administration of justice. They believe that laws, rules, and regulations are made by judges in the course of administration of justice. We know that there are three arms of government. That is the executive, the judiciary, the legislature. Okay? The executive, the judiciary, and the legislature. Okay? And these arms of government essentially are obligated with ensuring that there is separation of power. No one arm is supposed to control another arm, but at the same time, none of the arms is supposed to dominate in terms of act in excesses. And that's why at times you have seen conflict between parliament and the judiciary. You have seen conflict between the judiciary and the executive. You have also seen situations of conflict between the legislature and the executive. Okay, so these conflicts arise out of the push and pulls because every arm of government believes that they are the major lawmakers. Example, the first theory that we've looked at, the imperative theory of law, you'll realize that they are saying that there's a political sovereign. And when you equate it, you will understand that it's equivalent to the president or the executive as we know it. So they are saying that the executive, according to them, it's majorly the executive that is the lawmaker. Now, the legal realists are saying that no, lawmaking processes are preserved of the judiciary. Okay? Lawmaking processes are preserved of the judiciary. Okay? And when they say that, they are saying that we cannot have good laws, rules, or regulations if the judiciary is not involved. We cannot have good laws. Sorry, I'm transitioning. Laws rules and regulations unless you cannot have good laws, rules and regulations unless they are made in participation with the judiciary. Okay? How true that is, it all depends in practice. But you will appreciate that in the cause of separation of power, okay? In the cause of separation of power, every arm of government is given its own duties. And they are supposed to undertake these duties without them being in conflict within their operation. What we are supposed to see or what we are supposed to have are just checks and balances, okay? Where one body is checking on the other, but we are not supposed to see a situation where there is competition, okay? They are supposed to have coordination and not competition. So at the end of the day, as an engineer, Brian, you're really happy. Huh? Brian, how are you? You're enjoying the class.
No, no. We are fine, thank you.
Yeah. Now when you're enjoying, you have to concentrate in class, not regaling your friends with tales. Eh?
Yes. I'm making jokes.
Okay. Okay. So that is good. Now, the next theory, I said that the theory that we are now looking at is legal realism. Okay? And they say that laws are principles enforced by courts. Okay? Laws are principles enforced by courts. And they are saying that laws come from judges. Okay? And you cannot say that laws come from other people, other spaces, or anything else. The legal realists believe that laws come from judges. They want you to forget the fact that there is an indication that laws, rules, and regulations are coming from, I don't know, the political superior, you know, that gunman law principle. They want you to forget about it. Okay. And this theory was propounded by different people. We have Oliver Wendell Holmes, we have Gray, Cardozo, and Joram Frank. Okay, those are the names. We have Oliver Wendell Holmes, we have Gray, we have Cardozo, and we have Joram Frank. And the father of this theory is Salmond. He's the one who brought it home. Okay? And according to them, you cannot have, they like contemporary positivism, or they are contemporary positives. Example, we are saying that laws, rules, and regulation, according to Austin, emanate from some political superior. Then they are saying that forget about any political superior. These laws come from judges, okay? And it says that it's an expression of the will of the state, okay? And it cannot be a generalization of facts the way the positives think. So what are the basic features of this theory? Okay? They are saying that law is not predictable. According to them, law is not predictable, okay? Because if you look at the initial theory that we looked at, the imagination is that laws are predictable. The political superior will wake up in the morning and formulate laws, and you know, that is what they will be. But here, if you're saying that laws are made by judges and magistrates in the course of their decision making, it means that they have to follow the rules according to the facts presented before them, because judges and magistrates don't just wake up in the morning and make cases and make rules. No, these rules come from the cases that are presented before them. So unless a case is presented before a judge will not be moving because they don't know what to do. Okay? Therefore, it's not predictable. The facts that are being presented before them are not the same as the one that maybe they faced yesterday. So this draws an uncertainty, because what if these people are talking about the same thing, but they are using different facts. Does it mean that we'll have conflict in laws? Okay, I am saying that they do not support the formal, logical, and conceptual approach to lawmaking. They are saying that the lawmaking process is emotive. Why? Because if a case is before the judge, and this case, let's say, involves someone in your class, where this person is saying that they were not able to graduate because there were laws in place, and just laws, that were making them go through class for 5 years, you know? And these 5 years are too many. Why should you be in school for 5 years? And you said that after 3 years, in fact, after the first year, you are able to understand all the concepts because you are a genius, and therefore, they need to scrap. Sorry, this 5-year policy. You see, this is an emotive issue because you have missed to graduate, okay? And therefore, you cannot start, the judge cannot start applying so much logic to it. They should look at the facts, the way this thing has affected you, and make a decision, okay? If your emotions are just mere emotions and they're not taking into consideration the fact that at the end of the day, the laws, rules, and regulations that are supposed to be made will affect a generation to come. And not every generation is blessed with such kind of genius tricks, okay? So they have to make their decisions. And then they say that this theory lays greater stress on psychological approach to proper understanding of law because it looks at human behavior. The judges and magistrates look at human behavior based on the facts presented before them and how all this is supposed to take place, okay? They prefer to evaluate any law in terms of its effects, okay? They look at the law in terms of how it is affecting the society and not merely its application, or rather not merely how it's presented to them, okay? And there are, of course, criticisms that have been leveled against this theory. Why? The first is that judges apply and enforce law rather than defining it. They're saying that judges don't make law. Theirs is to apply the law that has been made by the legislature and the executive, okay? Then they're saying that case laws are not the best sources of law. Why? Because they change every day. Are you saying that if people come up with different facts for a certain situation, it will change the law? Then when another person comes, it will change because laws, rules, and regulations change at the inception of the facts, and they also change at appeal. So are you saying that when it goes to appeal, it's going to change, okay? Then it says that quite a number of lawsuits never reached court, okay? There are people who are disgruntled, who have problems, but they never go to court. Why? Because some of them consider the process to be so long, that is one. Others consider the process to be too untidy. Others consider the process to be tedious. Others consider that, others consider that it's costly. So at the end of the day, all these factors make people not to go to court, okay? And those are weaknesses, okay? And they're saying that the realists have exaggerated the role of the judiciary in the process of lawmaking. And they're saying that judges and magistrates are just people, okay? And if one person is given so much power to determine a fact that then becomes law that governs so many people in the world in terms of billions, then it essentially means that that role given to them is so exaggerated. And that's what they're saying. So what are the weaknesses of this theory? Or rather, no, those are the weaknesses we've looked at. How is it relevant to your discourse as an engineer? How is it relevant to your discourse as an engineer? First, the realist school of thinking is quite relevant to your discourse as an engineer for first the fact that the way the laws, rules, and regulations change based on emotions. Your training as an engineer, civil engineer, is also emotional. Why? Because whatever you're doing affects the public directly. Okay? Whatever you're undertaking affects the public directly, members of the public. If you come up with a bad bridge, it gets to collapse. It will affect so many people. If you come up with contracts that are beyond the imagination of the common society, then it essentially means that it will affect people, okay? If you decide that, let's say we are constructing the road, and of course we have the plans and everything in place, but it is so expensive, it means that the country will not be able to develop. And even you on the other end will not earn your daily bread. So when we say that they've exaggerated the role of the judicial decisions, it then means that they are overlooking the contractual backing of an individual professional. What if you decide to set your own prices? Is it going to be challenged in court? And will the court then overturn? What if the engineers board decides something with regard to training of engineers, and then somebody challenges it in court? What is the effect of that if whatever they are doing are good laws? So these are the things that we need to look at and consider at the end of the day, okay? Are there any questions from class? Maswali? Okay, now that there are no questions, let us move on. From the realist school of thinking, let's go to the Kelsen pure theory of law. So who is Kelsen? Kelsen was Austin's student, the way you are my students today, okay? And what is Kelsen saying? Kelsen is saying that law is a norm of action, normative action. He's trying to move from the abstract sense of thinking. And he's saying that laws are norms, rules and regulations are norms, okay? He tries, of course, to modify Austin's theory of law, and he says that his law is pure, okay? it's a norm of action. It emanates from what is called the pyramid of norms, okay? So a pyramid is like this, yeah? And at the apex here is what he says there is what is called a grand norm, okay? Grand or basic norm. And from this grand or basic norm is where all laws, rules, and regulations trickle. And he says that there is purity in the grand norm, and essentially, therefore, there is purity in the other laws, rules, and regulations. And he says that we should not confuse or bring too much confusion in the law, in the course of the lawmaking. Law should be pure. And the confusion that comes with the thinking of, let's say, thinking that laws are related to sociology, psychology, economics, and all these things, they should be separated from law. Law should be pure, okay? But then the question that we always ask is, where did this grand norm at the top come from? Where did the grand norm in the hierarchy of norms come from? And we have always said that this grand norm is like the constitution, okay? So if you look at the Kenyan legal system, the constitution is considered the mother of all laws. So much so that if any law is formed in Kenya that is contrary to the provisions of the constitution, then those laws are null and void to the extent of conflict with the provisions of the constitution. The same way, the grand norm is the mother of all laws. And if there are any laws within the Kelsen's balance that go against the grand norm, then they are considered bad laws, okay? And he's saying that we should separate law from politics, sociology, metaphysics, psychology, and all these things. Why is he saying this? He's saying this because this is what Austin was saying. Austin says that law is a command of the sovereign backed by sanction. So it could be anything. Whatever the sovereign feels like saying, whether it's arising from the psychological angle, physical, and all this, it's the law. But Kelsen says that it has got nothing to do with the psychology. He's also challenging the legal realists who are saying that laws come from judges and magistrates in the course of their decision making. And what he's saying is that this psychological factor that emanates from the judges must not be brought within the law. There should be an assumption that the judges and magistrates are not even parties to this, okay? And there should be an assumption that at the end of the day, the judges and magistrates are just people, okay? And they just contribute. However, if they want to formulate specific laws, rules, and regulations, they should then, the judges and magistrates should then let it trickle from the grand norm. So what are the features of this theory? One, this theory is aimed at reducing chaos and confusion, which is created by the supporters of natural law philosophy. And you realize that the natural law philosophy believes that laws, rules, and regulations comes from a political sovereign, okay? Comes from a deity, a god, okay? And whatever that means to you, depending on your practice, okay? And therefore, he says that we should separate law from the philosophy of believing that laws come from some deity. They come from the grand norm, according to them. And he says that he deals with what law is and not concerned with what law is supposed to be. Okay? He's saying that law is a normative action. And we should not be worried that, the laws are going to come from the judges, or what the laws are going to come from this particular political superior, or the laws are coming from some space that we don't know. We should not be concerned with that. We should only be concerned with the law as it is, and not what it is supposed to be or to be. Okay? Then he considered law as a normative action. Okay, normative action in the sense that it has a continuous growth and development. Okay, and it is a normative science and not a natural science. Okay, and then he says that it's not concerned with the effectiveness of the legal norms, but only the fact that we have the laws, rules, and regulation. Then, of course, it's a formal theory. It's confined to a particular system of positive law within its operation. And people have criticized this theory widely. Why? Because for one to say that you should, in the course of your lawmaking, in the course of our lawmaking, we should separate law from psychology, sociology, economics. So the question is, where are we getting our laws from? Because in the course of lawmaking, you have to do, you have to seek the opinion of the rest of the public. You have to undertake public participation. And when you are undertaking public participation, you are looking at the psychology of these people who are giving you opinion. You are looking at this as at the philosophy. You have to consider the economics. You have to consider the sociology that goes with it. What about the community? What are they saying? So this is what is supposed to guide in the course of lawmaking. So if Austin is saying that, if Kelsen is saying that no, laws should be pure, the question then is, where did this norm come from? Where did this grand norm at the apex come from? It is a chicken and egg situation. And that's why he's being criticized. He's been criticized widely. Then one, there's no dualism between state and law. Okay? He is saying that there's no dualism. The way people would want us to think, okay, in terms of separation of power. In our system, we have the executive, the judiciary, and the legislature. And if you look at the legislature, there's the upper house and the lower house. Upper house is Senate, lower house is Parliament. Within the judiciary, we have the highest apex courts and we have the lower courts. That is the Supreme Court, the Court of Appeal, the High Court, and then the Chief Magistrates Courts, which are lower courts. So there's always the dual manner of doing things, okay? And the president, we also have the president and we have the deputy and their cabinet. So there's always that hierarchy, there's always the dualism for purposes of understanding the trickle-down effect. But he says that the state should be unitary. There should be unity of legal order. There should be no dualism between state and the law, okay? And then secondly, he's saying that law need not be imperative, okay? Austin says that law is imperative. It's made by the sovereign, okay? And the commands that follow it is what brings out the imperative nature. But he thinks that sanction, Kelsen thinks that though sanction is a necessary element, command of the sovereign as it is unnecessary, okay? Why? Because once people agree with the law, the laws are created, then the presumption is that they are good laws and people are going to follow. And there's no need of punishing them to make them follow, okay? And then next, customary law is also law in strict sense. So what he's saying is that, you know what? When we are talking about the grand norm, and that this grand norm or basic norm is the one that creates these other laws, he's saying that these other laws, like customary law, family law, law for engineers, these are laws, okay? Or engineering as so stipulated. They are laws in strict sense. They are laws in their own rights, but you should separate them from governance. So him is concentrating in governance and separating governance from other laws, okay? Then, of course, he's saying that there is no relation between private and public law. Why? Because he's saying that there has to be a difference between the sovereign and the people. The people receive laws from the sovereign, and therefore they should adhere to what the sovereign says, okay? And this theory, the features as defined, this theory has been criticized widely. Why? First, because it excludes reference to social facts and the felt needs of the society. If you say that law should be pure, apart from the society, apart from the economics, apart from all that, it means that there's no sociological foundation. And therefore, what you're saying doesn't make sense, okay? And the purity of law, as he's saying, is not clear. Why? Just like I said, we don't know where the grand norm came from. Therefore, whatever it is not measurable. What is the grand norm? Is it a chicken and egg situation? The question is it the chicken that came first or the egg? Or where did the egg emanate from? So that has been criticized. And then people are saying that whatever he's saying is hypothetical. Okay? What do I mean by this? It's hypothetical because he doesn't, even him as a person, he doesn't understand how the grand norm is coming about. It is so theoretical and it cannot be applied in the practical sense. How do you go out and come up with laws and say that you're not supposed to have public participation? This is what has made the government lose out in most sense, because the courts normally throw out most of the laws saying that there wasn't enough public participation. Okay. But of course, there are some merits that arise out of that theory, and those ones should be appreciated. So how is this theory relevant to your discourse as engineers? How is it important to you as an engineer? One, the specialization effect. He's talking about the grand norm at the apex here. And these other laws are down here, okay? But you'll realize, you'll appreciate that since you started your training, yes, we are teaching you law for engineers, you're being taught ABCD, but at the end of the day, you know that you're a civil engineer and you're supposed to be good at principles of engineering and in particular, civil engineering. You are not supposed to digress so much. Even if you're looking at law for engineers, you're not supposed to look at too much law. That is specialization that Kelsen is talking about. And that is applicable to your system. Second, he's talking about the grand norm at the apex, and that these other laws have a trickle-down effect. This is applicable to you in the sense that you know that down here, there is engineering, okay? There's a law, or there are laws, rules, and regulations that govern your practice. While up here, the grand norm is none of your concerns. So this is essentially applicable to you because after people have made laws, rules, and regulations, or after people have gone through the processes and the procedures that need to be done, you know that at the end of the day, your duty is with regard to the laws that govern your practice. Okay. And then when it comes to looking into the society and ensuring that there is purity in the law and lack of confusion. Imagine you went out and, you know, you are an engineer, you're supposed to be a civil engineer, but you go out and start looking at so many other things, you know? You look at so many other things. It essentially means that you will miss out, okay? You will miss out. And if you miss out, then how do you manage? How is your situation managed? If you lack specialization, then it essentially means that you cannot be a good engineer. An engineer who is saddled by everything else but the things that really are applicable to their area will essentially be a half-baked engineer. Okay. And then finally, the matters, economics and contracts and all that. He says that, yes, we are supposed to have those laws, rules, and regulations, but they are supposed to be separated from the governance structure, which I tend to agree with him. Why? Because after you're done with your studies, You will be an employer, an employee, or a consultant. You will be engaging at different levels. If there are no specialized laws, rules, and regulations that govern your practice, then it essentially means that you'd be lost. And that's why we have the engineers board to guide and the various professional bodies in other areas to guide. Okay. Are there any questions? Brian, Zachary, Tanya, Arnold, are there any questions so far? Maswali? Zachary, no question. Elvis, Evans, Fidel, Hezron, Joan, Joel, John, then Juma, Elijah, Kagonye. Any questions? Obadiah, Maureen, Swali. Kenya 1. Are there any questions? No questions, no questions, no questions. None. Okay. It means people are understanding. Also, I want to imagine. So we've looked at imperative, we've looked at Kelsen, we've looked at the legal realists. Okay. Historical and sociological, we looked at. Would you mind repeating on customary points? Okay. Customarily, if you look at the Kelsen's theory of law, he's saying that law emanates from the grand norm. It's a normative course of action, okay? And that the grand norm is here at the apex. And this grand norm is the one that trickles laws down to other areas. So he's saying that you can come up with your own laws that govern custom, economics, sociology, and all that. But what we are saying is that we are questioning where the grand norm came from. Because what we are seeing Kelsen do, Kelsen is inviting us to celebrate an illegitimate child without questioning who the father is. Okay? And this illegitimate child is the grand norm. Who is the father of the grand norm? Where is the grand norm coming from? Who is formulating the grand norm? We are not being told. And we are not supposed to ask. So what we are saying is that at the end of the day, the customary practices within a society determine the kind of laws, rules, and regulations that we have. The practices in our environment determine the laws. So if we say that in the course of lawmaking, we are separating custom from the political legal principles, then it means that we'll be lost. What would be the basis upon which we are changing laws or making laws if we don't look at the customary practices? So that essentially is what custom is. Any other question? Swali zingine kutoka class? Okay. So if there are no other questions, then I will leave you with this question that will form the basis upon which we'll have our next course of discussion as we go into, I don't know, Caesar, did I give your class the question on contract?
No.
Yeah?
No.
Did you say no? I can't hear you.
Yes, I said no.
Okay. Now, look at this question, and then we will discuss it. We will look at the natural law theory and tie it up with this question as we finalize the nature of law and go into the law of contract. Distinguish that, send it to my email. At tukenya.ac.ke. Send that to my email. Before the next class is Monday, okay? So, I hope everyone has copied that. I've sent it on the chat. So, what we are saying at the end of the day is that laws, for you to define law and get the concept of the legal principle right for purposes of application, we must understand the nature of law. And for you to understand the nature of law, you must understand the theories. So you have now realized that all the definitions of law that you have are coming from these different theories. All the features of law that you have are coming from this theory. And when you sit down with somebody and you know they are talking about law and the legal principles, you are able to tell them that what you're saying is from this particular theory. And you'll realize that even our form of governance in Kenya, if you have been following and listening keenly, you'll realize that they are so correlated to these theories. So these theories cannot be separated from the governance structure as we have it today in Kenya. They all depend on it, they emanate from it, and they're so related to it. Is that right? So what we should be asking ourselves is, what then is the nature of law? What then is the nature of law? And that comes from the various theory. We say that laws are rules and regulations that govern our day-to-day affairs. That one is from the imperative school of thought. Law is the normative cause of action. The nature of law is that it operates within certain norms to help us get the end goal. That comes from the Kelsen school of thinking. If we say that laws are rules and regulations that are used by the ruling class to control the rest, that comes from the Marxist school of thinking. If we say that laws are rules and regulations that are made by judges in the cause of administration of justice, that comes from the legal realist, okay? If we say that laws are practices that emanated from long time ago for purposes of governance and management of our affairs, that is from the historical school of thinking. So at the end of the day, whichever way you turn, it means that you are looking at a specific area and the nature of law is emanating from the different schools of thinking in terms of theory. Any questions that far? Maswali? Maswali?
I have a question.
Yes.
You have said in Kenya, the law, we combine all the theories. So if you are in the court, which theory will be the judge be using? Or it depends on the situation?
Sorry, I missed about before the judge. What did you say about the judge?
Is there a specific, the law of Kenya, which theory is it based on?
Okay. If you look at the Kenyan governance system, and you're in the court, okay? If you're within the court system, you'd realize that when somebody goes to court, let's say, which is the hot topic currently, there are so many things that have come up so far. We have the NHIF issue that went to court. We have the housing levy issues that went to court. You'll realize that those things, or the issues arising out of that, the people who are going to court are trying to say that their human rights have been violated. How so? Some of them are saying that there was no public participation, okay? Some of them are saying that though there was public participation, the laws, rules, and regulations as formulated will violate their human rights, okay? And if you look at the angle at which they're approaching, and look at the imperative theory of law, the imperative theory of law says that laws are commands emanating from a sovereign, which are backed by sanction. Now, if you look at these laws, rules, and regulations that have gone to court, they are saying that a certain percentage of money is supposed to be deducted from payslip. If an employer fails to deduct that, there is sanction to it, okay? So, at the end of the day, when these cases go to court, the judges, if somebody is saying that there was no public participation, the judges are supposed to ask themselves whether these interest groups were presented in parliament when these laws were being made. And that's the reason why you have seen for affordable housing, it has gone back to parliament, okay? It was taken back to parliament for public participation. Why? Because there was a feel that everybody was not included. And when we are talking about public participation, it doesn't mean that everyone has to talk to it. No, it means that we have interest groups. Let's say you as engineers, you have your engineers board. Second, as students, you have the students' union. Third, as let's say an institution, you have the university management board. They're supposed to look at all these laws, rules, and regulations on your behalf. And then when they go for public participation, not all of you in class are going, but either your president will go to the parliament to present your views, or the university board, one person will go to present your views, or the engineers board will go to present your views. So at the end of the day, if the legislature, that means parliament, is able to come up with present minutes and present lists in court and present, let's say, the proceedings, that would then say that no, there was public participation. These people came to, their interest group was well represented. Then the court will be throwing out that argument where people are saying that there was no public participation. And when court throws out that and upholds the decision of the legislature or the parliament passing that law through the executive, it would mean that they're acting under legal realism. They are stamping their authority and saying that what the parliament did and the presidency ascended to is good law, and therefore we should follow it. If they say that it's bad law and therefore we should not have it, then we will still be having the legal realist theory, and we will have the natural law school of thinking, where there is a superior being who is passing down authority and wisdom, and this wisdom and authority is supposed to trickle down to mwananchi. We will also be having historical school of thinking, because in the course of looking at this case, the judges are supposed to ask themselves, what was the position before? How is it going to be affected? And why is it so important? That is history. They will also be looking at the sociological. How so? What does the society want? But apart from what this society is talking about, what is important for the society? What has been happening in the society that would then affect this moving forward, okay? And then the Kelsen's pure theory of law will also come into play, where they're saying, though we have considered all these factors, some of these things are not relevant. We will do away with them. And what we are looking at now is the purity within which this particular law is supposed to be applied in its context, because you're supposed to put everything into context. So if you look at all that, you'd realize that in the course of lawmaking, the imperative theory plays a role, Kelsen's pure theory is there, historical and sociological are there, the natural law school of thinking is there, and then the legal realist. The Marxists will also come and say that the court will look at the Marxist angle, where they'll be asking themselves, are these just laws in terms of the economics? Will the bourgeoisies, or are the bourgeoisies out to oppress the weaker class or the have-nots? Is it a class war, or are these just laws, rules, and regulations that are supposed to govern operations? Okay, so all that will be looked at. Does it make sense?
Yes, it does.
Okay, good. Any other question from class?
I have one.
Yes, Mutero?
In the ruling where the BBI was deemed unconstitutional because the president is the one who initiated it.
I'm really struggling to hear you.
Hello?
Yes.
Can you hear me now?
Put the mic close to your mouth.
Okay, I'm asking, in the BBI ruling, the
Yes.
court said that the president had erred, not because the law said he cannot initiate the popular initiative, but because the way the laws were made, they were made in order to curb the whatever was viewed as a presidential. I'm looking for the word to put there, but it was meant to ensure that it is only the citizens who can start it. So, which theory did the judges use to arrive at that ruling?
The BBI ruling, if you look at the BBI ruling, the way they said that, in fact, it was supposed to be started by the people, you realize that you donated your powers. As the people, you donated your powers to parliament. So, if it was supposed to be started by the people, it was supposed to be a bill that a person presents to their member of parliament. And this is social contract. And social contract is within the natural law school of thinking, where the citizens have donated their powers to the legislature. Your member of parliament represents your rights. So you are supposed to, if you are disgruntled with your training as engineers, you are supposed to come up with a proposed bill of what you'd like to see within your training, and you're supposed to give it to your member of parliament. The member of parliament is supposed to introduce it in parliament as a bill. Then it goes through the various stages, public participation and all that. So when the court was making that decision, it was saying that you missed it out at the social contract. Why? Because this was something that they were supposed to donate their powers, but that power that is donated is not donated to the executive. It was supposed to be donated to the legislature. So the natural law school of thinking applies there. But apart from that, the historical and sociological factors come in. Why? Because historically, they're supposed to ask themselves, this BBI, are these provisions in the Constitution? And what is it trying to cure historically? What has happened? What happened that brought us where we are? And what are we supposed to do? What is ailing us? And then now, the sociological, the society where we are at. What are the things that are ailing us that would be cured by this alleged BBI? Then, of course, the Kelsen's pure theory of law. What normative action, what grand norm is contributing to this BBI that the court then needs to look at? Then the imperative. Imperative, the pronouncements of the sovereign. The weaknesses that arise out of the imperative, where the sovereign decides and says something and there is sanction. So if you look at it at the end of the day, all these theories are applicable, but the major theory that then applies would be the natural law school of thinking, where we have the social contract theory. Does that make sense, or have you understood?
Yes, thank you.
Yeah, so what we are trying to say is that at the end of the day, one theory is not sufficient to cure the anomalies that arise within the limitations of the law. You have to look at it holistically. And that's the reason why when we started out, I told you, go and look for at least 6 theories. Because I know that there are major theories and there are minor theories that are emanating from these major theories. So having looked at that, and in the course of this discussion, I want to imagine that you have understood, because the questions have helped us understand what we are talking about. And I want to imagine that it has been quite robust. Are we on the same page? Is there any other question? Okay. Please share notes early enough. Yes, Zachary, Caesar already asked, so I'm going to share notes early enough. Any other question? Caesar, did you share the email and the class list?
No, you have not asked for it, but I'm going to share.
Okay, share the email and the class list with me. Somebody is saying repeat the deadline for submission of the work. Because we have a class on Monday, let me receive the work by Sunday. Okay? And then the apologies should be, we should do away with the apologies. Madam, I'm sorry. Madam, I'm sorry. Let's try and do away with them. Let's do the work. Sawa sawa. Okay? Any other question? Okay. If there are no questions, then I'll give you time for transition. Have a great week, the rest of the week, and have a great weekend. Enjoy your day.